Welcome back to another episode of Inside the Chambers. I'm your host, Bria Tai, and today we are here with Miss Shelly Nairn. Shelly is an attorney here at Hallsbury Chambers who specializes in mortgages, conveyancing, probate, wills, trust, and estate law. And today we are going to be answering some frequently asked questions about wills and probate. So thank you for coming on to the show, Shelly, and welcome. We're going to just jump right in with the first question. So what is a will and why is it important to have one?
Well, thanks again for having me, Ty. And I think this is going to be a really informative topic, and I hope that we're able to disseminate the information so that a lay person who is listening to the program will have a basic understanding of what it is we're trying to convey.
Absolutely.
So what is a will? So a will really, it's a legal document. The act says a will speaks from death, right? So basically what a will does, it dictates how a person's property, their assets, or any guardianship of dependents, etc., are managed or distributed after death. Hence the terminology, it speaks from death, right? Why is it important to have one? Because it speaks from death. If you don't have a will that says how you want your assets to be distributed or managed, then the law will do it for you, right? And you don't want somebody who you may not have had a relationship with become the executor of your estate because, as we like to say, you didn't handle your business, right? And so that's the reason why it's really important to have a will.
And that brings us right into our next question, which is what happens if somebody dies without a will?
So if a person dies without a will, we say that they would have died intestate. So if you die with a will, you've died testate. If you've died without a will, you've died intestate. And basically, again, the law of intestacy takes effect. And the law basically tells you how your assets are going to be distributed. So for instance, if you have a wife and children and you've died without a will, the law says your assets are to be distributed as follows: 50% to the spouse and 50% to be divided equally amongst the remaining children. And then it also goes down, there's a law of succession that also goes down as well. If there's no wife, then it's the children, etc. Again, that's the reason why you want to make a will.
Right. So what assets are typically covered in a will and what assets are not?
So your assets that are typically covered in a will would be the assets that you actually own, right? So in your will, you would list if you have bank accounts, properties, your car. Some individuals actually have like trade tools, anything that you consider an asset, your jewelry, your bracelets, your furniture, your plates. All of those things can be included in the will. Again, it's your instructions, right? What assets are not? Well, I would say like a life insurance where you have a beneficiary attached. Some people tend to put it in the will, but the will does not supersede where there's a beneficiary attached. So therefore, those kind of things really don't need to be in the will, right? The information that's actually in the will are really assets that have no beneficiary attached, assets left to the estate, yes.
So moving on to probate, what is probate and when is it required?
What is probate? So the probate is really a legal process, right? It really gives effect to that person's will. So everyone who dies, whether with or without a will, it goes to probate, right? Because again, if you have died with a will, it gives effect to that will, where it appoints the executor legally to allow the assets to be vested in that executor, and that allows the executor to distribute as per the will. Or if you die without a will, then of course the court makes the appointment of an executor once you've made the application. So for instance, if you have a parent who dies without a will, for instance, and the act says, of course, the law of succession will say the wife first. The wife would be the first person in line to be the executor unless she renounces. So it's a bit of a technical thing to understand, but again, if you die intestate, it's not lost. The law makes provision for that.
Yes. Typically, how long does the probate process take?
It takes Sometimes it can take months. It all depends on when the application goes in to the court. It depends on the possibly the court's diary, if the court is probably, the court's diary is full. Because again, it does have to go before a judge, right, for the application to be approved and for the executor to be appointed by the court. So it's difficult to say how long it's going to take. Or if there's something missing, sometimes the court might come back and say, well, I'd like to see this document or something like that. So it all depends. It can take a year, it could take 2 months, it could take a month, but every situation is pretty much different. It all depends on the circumstances.
Who is responsible for applying for probate?
So the individual or individuals responsible would be the individuals named as executors in the will. That is, if you died with a will. If you die without a will, of course, the law of succession will take place. So if it's the wife, he has a wife, would be the wife first. If there's no wife, it would be the children. And if they're children, they're all entitled to apply equally. So it all depends on the circumstances.
Can a will be challenged?
Yes, it absolutely can be challenged. So you have cases where a will is challenged if the individual making the application wasn't supposed to make it in the first place.
Okay.
Right? So because if you have a will, automatically you know who the executor is. Unless for some reason the executor is deceased, again, there are laws, applicable laws for those situations. But you have cases where an individual might have falsely, and it's a few and far between, I would think, but you do have circumstances like that where you've had the person who made the application was given a grant of probate, but on further, I guess, maybe if someone dug further, I personally have never had a case like that. They realized that the person who would have made the application and was given the grant of probate was not the individual. And so they've challenged that. So you do have cases where there are challenges. I mean, nothing is absolute, right? So you will have cases where certain people made an application and they were not the or should I say fit and proper individual to make the application.
How often should a will be updated?
I consider a will a living document. Right? You could update your will every day if you want. Every time you've gotten an asset, you should update your will.
Right.
Right? And that's why I consider it a living document. It is not that, I wrote it and I don't have to go back and touch it again. Anytime you have gotten an asset, you've obtained an asset, and I'm talking about more of a fixed asset like land, not necessarily a car, I would say that you should update your will. Yeah.
What are some common mistakes that people make when first creating their will?
The most common mistakes I find is that people don't list all of their assets. They think that they don't have anything per se except the piece of land that they have, but your jewelry is an asset. Some people have really nice watches, that's an asset. The either is to capture everything in the will. If for some reason you were to die, and some of those things are no longer applicable, then the gift will just fail, right? You might have disposed of the car, you might have disposed of the watch, but it's better that you capture it in the will than you don't put it at all. And then some cousin, some brother who you and him never had a relationship ends up getting your stuff, so to speak, because you did not include it or you didn't make a will. And your assets end up being in someone's hand. That's how to me I think of how properties go out of your family's hand. Because you didn't make a will, something happens, it goes to the wife, right? You might not have had any children, you die intestate, your property goes to the wife. The wife dies. Well, instead of it going down to your generation, it now goes down to her generation, right? So anything and everything. You can put whatever you want in your will as long as it doesn't offend the law. And that's the bottom line. So how often should you update your will? As often as is necessary. And that is really the bottom line.
Right.
Yeah.
Yeah. And a key note to take away from this from this episode is that when you are drafting your will, it's important to make sure that it is as specific as possible.
Correct.
So make sure that your attorney is clear on what your wishes are.
Correct.
So that they are properly executed in that will.
And I would like to add one more thing about what should be covered when you're drafting your will. One of the things we need to take into consideration as well is that when you have minor children, you really, and you should, ought to have 2 executors. And those 2 executors ought to be responsible individuals who are going to comply with your wishes with regards to how you want your assets to be disposed of for your children. Because remember, when you have executors, they're holding your assets in their hand. And so you want to be really, really sure that when you are drafting a will and you have minor children, that you have fit and proper executors who are going to follow your wishes, and they're not going to take your children's assets and the children not end up with nothing.
Right.
And that's really, really important for them to remember.
Right, absolutely. Thank you so much for this information, Shelly.
You're welcome.
Thank you for tuning in to this episode of Inside the Chambers. If you enjoyed it, please like, subscribe, and comment, and stay tuned for more episodes soon.
Thank you.